Hello, welcome to VidhuLaw Neethi. In Code of Civil Procedure, we are going to learn about the different kinds of jurisdiction of civil code. Now let us learn in detail in upcoming slides. In this video, we are going to learn the meaning of the jurisdiction and kinds of jurisdiction of the court. The concept of jurisdiction is a fundamental in understanding how court operate in any legal system. Jurisdiction refers to the authority granted to the court to hear and decide the legal cases. The Code of Civil Procedure 1908 lays down the rules that define the jurisdiction of civil court in India. The jurisdiction has not been explained in the Code of Civil Procedures. In simple words, it can be described as a power of the court to settle the matters. The Indian judiciary has invoked the ancient legal maximum, that is, ubi jus ibi remedium, which means that where there is a right, there is a remedy. The judicial form must have jurisdiction to deal with that matters. Hence, the jurisdiction commonly rests where there is a crime is committed. In general and legal sense, jurisdiction means power to hear and determine the cause of action or dispute of civil nature through judicial powers. There is one case called Official Trustee versus S.N. Chattigar. After referring various decisions, the Supreme Court observed the jurisdiction must include the power to hear and decide the issue or dispute that has been arisen between the parties. Now let us learn the kinds of jurisdiction of the court. In the first one is territorial jurisdiction. It defines the geographical area and tells which the authority of the court lies, and the court is competent to hear and decide the matter. Any matter tried outside the territorial jurisdiction of the court can be termed as void or voidable. That is, the court cannot exercise power outside its territorial jurisdiction. Under Section 16 of CPC 1908 defines the territorial jurisdiction with respect to immovable property. It is very important to file the matter in the court with proper jurisdiction. Next one is pecuniary jurisdiction. It refers to the monetary value of the case that the court can try. Generally, pecuniary means involving money. So, pecuniary jurisdiction defines the competency of the courts to hear and decide the matter on its pecuniary or financial value. Each court has its own different pecuniary jurisdiction under which it is allowed to exercise its powers. Pecuniary jurisdiction is predetermined and helps in reducing the burden of the high courts. Next one is jurisdiction as subject matter. Each court has predefined subject matter under which it specializes to hear the matter like civil courts, criminal courts, family court, electricity tribunal, commercial courts, etc. Each court is determined to hear and decide the matter particularly related to the subject matter only. That is, they cannot hear the matter related to any other subject matter. Civil courts can only try civil matters. Any criminal matters is filed in civil court is not maintainable under law and will be dismissed. Next one is original jurisdiction. It defines the powers or authority of the court to decide the matter in the first instance, that is fresh matters. Each court has its own original jurisdiction to try and decide the matter. While exercising this jurisdiction, the court can conduct hearing, record or take evidence and determine facts of the laws. It also be set as a fundamental power of judiciary to adjudicate matter and resolve them. The Supreme Court of India can exercise original jurisdiction under Article 32. Next one is appellate jurisdiction. It defines the authority of the court to hear and already decided matters by the subordinate courts. This jurisdiction is exercised by the higher courts to fix the errors or correct the mistakes or prevent injustice if anything is done by the subordinate courts. Appellate jurisdiction can be only exercised by the Supreme Court and High Court. Next one is non-current jurisdiction. It arises when two or more courts simultaneously have jurisdiction over a single particular matter. That is, all of these courts have the jurisdiction to try and decide the matters. Parties in the situation have to file the matter in any competent court which is favorable or nearby them. Thank you. Please like and subscribe.